Hello and welcome to the video for the feedback on assignment Legal 1. My name is Fred Hopma and I will discuss the answers to the questions of assignment Legal 1. Let's go to question number 1. It says, suppose the traffic on National Motorway A1 in the Netherlands is increasing. Every morning there are traffic jams. Engineers conclude that the motorway needs to be widened. To be precise, one lane needs to be added in one direction of the motorway. The question is, which legal procedure needs to be followed for the widening of the motorway? Well, let's go to the answer. The answer is that the so-called shortened procedure, as laid down in the Infrastructure Planning Act, needs to be followed. There is no need to follow the full procedure. This is the motivation. It is given in the question that only one lane needs to be added to the motorway. In that case, there is no need to draw up a structure vision. A structure vision is part of a full procedure. A structure vision needs to be prepared if the minister takes into consideration to add more than 2 lanes to an existing national motorway. Article 2, paragraph 4, Infrastructure Planning Act. There is yet another reason why no full procedure needs to be followed. If there is no freedom of spatial choice, the shortened procedure will be followed. Well, in case of adding a lane to an existing motorway, there is no freedom of spatial choice because the extra lane will be constructed adjacent to the existing motorway. Most students answered this question good. I have a tip for the exam. Refer, if possible, to articles in the Act. Here in this answer, reference could have been made to Article 2, paragraph 4 of the Infrastructure Planning Act. This article has the effect that the full procedure only applies to situations in which more than 2 lanes are added to an existing national motorway. So refer to articles. If students only mentioned the reason that there is no freedom of spatial choice, 7 points would be given instead of the full 15 points. If students answered that the shortened procedure will be followed without reference to one lane or the fact that there is no freedom of choice, 5 points would be given. If the answer was the shortened procedure because of modification of existing infrastructure, 7 points would have been given. So, if not the full correct answer was given, a deduction of points has taken place. Let's go to question 2. Who, that is which actor, has the power to take the legal decision to widen a motorway? The answer is that the Minister of Infrastructure and the Environment takes the track decision. So the correct answer is that the Minister is the actor who has the power to take the legal decision to widen the motorway. However, procedures do not necessarily end after that the track decision is taken. Interested parties have the power to lodge appeal with the administrative judge, and the judge will test the track decision against the legal framework for decision making. As said, the judge will test the decision of the minister. But technically, the judge does not take the decision to widen the motorway. What the judge can do is to nullify the decision of the minister. So the correct answer is the Minister of Infrastructure and the Environment. Quite some students in their answer refer to the so-called 3 domains of power: the administrative, politics, and justice. That answer also was given the full 15 points. If you answered that the ministry has the power instead of the minister, 8 points would have been given. If your answer was that the state has the power, 2 points are given. The state is not specific enough. And the government, if that was the answer, then you would have given 0 points because that is not specific at all. If your answer was the administrative jurisdiction division of the Council of State, 4 points would have been given. As explained, the court only tests the decision, but actually does not take the decision, it nullifies it. The prime actor is the minister. Question 3. Land is needed for the widening of the motorway. The land needed is owned by a farmer. He uses the land for agricultural purposes. This farmer refuses to sell the land. The widening of the motorway is recorded in the municipal land use plan. Subsequently, the national state expropriates the land. The question is, which financial compensation does the farmer receive now that his land is expropriated? Is it the value of the land under the current use, as farmland, or the value of the land under the future use, motorway? 15 points maximum. This is the answer to question 3. The textbook Planning and Development Law in the Netherlands on page 26 explains that the compensation is either based on the value of his land and buildings erected on it under the current use, for instance as agricultural land, or the value of the land and buildings taking into account the future use, for instance residential area, however in this case motorway, depending on which of the two is the highest. Well, in this case, it's not exactly sure which value is the highest, motorway or agriculture, but anyway, the highest will be compensated. A remark. I noticed that quite some students mixed up the planning compensation and expropriation in their answer. Take note that planning compensation rights are different from expropriation. In case of planning compensation, ownership, property rights are not taken away. In case of expropriation, property rights are taken away. So this is an essential difference. In both cases there will be compensation, but in the case of planning compensation rights, not because ownership is taken away, because ownership or property rights are not taken away. There were various answers given by students, and many students had the full, complete answer when given 15 points. But if your answer was the land use plan that is the basis for expropriation is the starting point, 10 points would have been awarded. If you explained the elimination principle as explained in section 2.5 of the book, 15 points would have been given. If you said the value of the land is decided by the future land use in the land use plan, 8 points would have been given. If you would have said the farmer has the right to complete compensation which is based on the highest value, 3 points were given, because this is an incomplete answer. It's too short. It does not explain what is the highest value, what the highest value means. Question 4. What is your opinion? Should, in case of expropriation in general, so apart from this specific case, the value of the land under current use be compensated, or the value of the land under future use as indicated in the land use plan? Give arguments. Well, there was a great variety of answers. The quality of your answer was assessed. In particular, I assessed whether the arguments you gave have a logical connection with your choice for value of the land under current use or value of the land under future use as indicated in the land use plan. Again, quite some students confused planning compensation rights with expropriation. These are different things. Both answers, value use or future use, are correct if a logical and sound argument was given. For instance, in many countries the current use will be compensated and not the value of the land and buildings on the property market. One could say that the value of the land under future use, as indicated in the land use plan, must be compensated because this value reflects the real value of the land on the property market. and it is fair to compensate the real value if that value is higher than the use value. On the other hand, one could say that the use value must be compensated because the owner is forced to end the current use. And one could say that the owner of the land should not profit from the new land use objectives if the new land use plan projects a more profitable function on his land. Indeed, it is the local government that decides on the new land use and not the owner of the land. So there is no reason why he should receive more money than the use value. Again, arguments in favor of both viewpoints can be given. If an argument was given but it does not logically lead to the conclusion, then a deduction of points was awarded. Question 5. Suppose that the municipality on whose territory the motorway runs is opposed against the widening because of its environmental effects for the local community. Think of air pollution, noise, and so forth. Does the municipality have the power to appeal to a judge? 10 points. No, municipalities do not have legal standing in case of national infrastructure decisions under the Infrastructure Planning Act. This is laid down in the Crisis and Recovery Act, Article 1.4. So this question required a fairly short answer. If the motorway is not a project on the list of the infrastructure projects of the Crisis and Recovery Act, the municipality does have the power to appeal to a judge. Some students referred to that, and that answer is also completely correct and was given 10 points. If students answered correct but did not refer to Article 1.4 of the Crisis and Recovery Act, 1 point was deducted, and so 9 points were given. Most students answered this question correct. Question 6 continues. What is your opinion? In general, so apart from this case, is it a good thing that one government, the municipality, has the power to appeal a decision of another government, national government, in court? Give arguments, 15 points. Here again, as in question number 4, both viewpoints can be taken by students, and it is the quality of the answer that is decisive for how many points you were given. Arguments for the viewpoint that it is a good thing that one government, municipality, has the power to appeal a decision of another government, national government, in court. If the power to lodge appeal against the national governmental decision exists, the municipality will be taken more seriously by national government. That is, the arguments of the local authority will most likely be taken more into account as compared to the situation in which the municipality does not have the power to lodge appeal. Without the right to appeal, national government could easily override local views regarding the project. Quite some students use this argument, and it's correct, and was given 15 points. Arguments for the viewpoint that it is not a good thing that one government, the municipality, has the power to appeal a decision of another government, national government, in court. Branches or tiers of government should not fight each other in court. That would be an inappropriate use of taxpayers' money. Both municipalities and national government are organs of the same state. They should consult with each other and try to solve problems through negotiations. That answer was also given by many students. And if it was a little bit substantiated, 15 points were given. Other arguments can be used too. For example, some students answered that a clear hierarchy must be in place to make sure government works swift and adequate. Therefore, a municipality should not have the power to appeal against national government. What is important for grading is the quality of your answer. Both choices are okay. Power to lodge appeal is good or power to lodge appeal is not good. number of points you receive depends on how solid your motivation is. And so there are slight variations of the number of points you were given as an answer to this question. Question 7. The decision to widen a motorway is, amongst other things, based on a prediction of the environmental effects of the widening. Suppose that after the opening of the widened motorway, the road attracts much more traffic than expected. Hence, the environmental effects are more severe than predicted. Now what, from a legal viewpoint, is this just the way things sometimes happen? 15 points. No, it is not the way things sometimes happen. The Infrastructure Planning Act stipulates that each track decision holds a term for evaluation of effects. Article 10, paragraph 1, sub F, Infrastructure Planning Act. This is the evaluation test. Article 23, Infrastructure Planning Act, expresses that the predicted effects have to be evaluated in practice. The textbook Planning and Development Law in the Netherlands on page 102 explains, it is possible that the evaluation reveals that the effects on the environment are more severe than predicted. Should that be the case, the Minister will provide a description of complementary measures that are necessary to still meet the environmental requirements. Moreover, he will specify the term within which these measures will be realized. So, if this is the case, additional measures must be taken to mitigate the effects of the environmental effects that are more severe than predicted. Most students answered this question correct. If reference to both articles are missing, Article 10 and Article 22, for each 1 point is deducted. Some students answered that planning compensation would be the result from a legal viewpoint. That answer receives 3 points because planning compensation could be suitable in this case, but are not dependent on increase in environmental effects. If an answer misses the term evaluation test, but for the rest is correct, 3 points are deducted. A number of students gave a correct answer regarding the environmental impact assessment, that environmental impact assessments also require evaluation. That would be given 10 points. That answer is a little bit less strong than reference to the specific Infrastructure Planning Act. Plus, not all decisions regarding widening require an environmental impact assessment. If an answer was government can take retroactive actions, that kind of answers would be given 8 points. And if students answered that government should invest in new measures, that kind of answers would be given 6 points. They have no reference to the Infrastructure Planning Act and are not specified enough. I hope this clarifies the points given and the final grade. The vast majority of students has a fine grade for this assignment. I hope you learned from this feedback. For instance, that the quality of the answer is important, that you need to motivate adequately answers, and you need to refer, if possible, to answers of the acts. So far, this feedback on assignment Legal 1.